Hirachand against Hirachand and another.
Lord Richards will explain the decision of the court.
This appeal concerns success fees which a party may agree to pay their lawyers if they win a case. The general position is that success fees cannot be recovered from the losing party under a costs order. The issue in this appeal is whether provision for a party's liability to pay a success fee can be made in an order for financial provision out of a deceased person's estate. The facts briefly are as follows. In August 2016, the appellant's husband died in the tragic circumstances of a domestic house fire. His widow has significant health problems and will spend the rest of her life in residential care. The deceased and his wife have an adult daughter, but they had been estranged from her for some years. The daughter has severe health problems and at the time of her father's death did not have sufficient income or assets to support herself. Under his will, the deceased left his entire estate, valued at £554,000, to his widow. Their daughter issued a claim for reasonable financial provision from her father's estate under the Inheritance Provision for Family and Dependents Act 1975. The daughter could not afford the necessary legal fees and so entered into a conditional fee arrangement, also known as a CFA, with her solicitors in order to fund her claim. The CFA stipulated that if the daughter's claim failed, her solicitors and counsel would not be entitled to any fees. However, if her claim succeeded, she would be liable to pay their fees and also a success fee equal to 72% of the fees. The daughter succeeded in her claim for financial provision, and she was awarded a sum of £138,918. Her success meant that she became liable to pay her solicitors and counsel's fees and also the success fee. The general rule in civil litigation proceedings is that the successful party can recover their reasonable legal costs from the losing party. In this case, an order was made for the daughter's reasonable and proportionate legal costs to be paid by her mother. Because of the prohibition on the recovery of success fees by way of a costs order, contained in Section 58A(6) of the Courts and Legal Services Act 1990, which was introduced by amendment made in 2012, a similar order could not be made in respect of the success fee payable by the daughter to her lawyers. The judge decided instead to include a contribution of £16,750 towards the success fee as part of the substantive order for financial provision under the 1975 Act. He held that as the daughter had no choice but to pay the success fee to her solicitors, it formed part of her financial needs, to which the court must have regard in determining the order that it should make. The widow's appeal was dismissed by the Court of Appeal, which drew an analogy with orders made in financial remedy proceedings in matrimonial cases, where it is well established that provision may be made for costs, although not for success fees, as they are not permitted in family proceedings. The widow appealed to this court on the ground that there is no power to make provision for the payment of success fees in orders for financial provision under the 1975 Act. For the reasons stated in the judgment being given today, this court unanimously allows the appeal. There are two principal grounds for the court's decision that provision for success fees may not be made in such orders. First, it is a long-established common law rule that the costs of civil proceedings are dealt with in those proceedings exclusively under the applicable regime for costs and not as part of the substantive relief. So, for example, the costs of an action cannot form part of an award for damages made in those proceedings. The rules and principles of the costs regime serve the proper administration of justice, but by providing for consistent and just outcomes. And the rationale of the common law rule is that otherwise the coherence of the costs regime would be undermined. Success fees are part of the costs incurred by a party, and the fact that they are not recoverable from another party does not provide a ground from departing from the common law rule. There is no indication in the 1975 Act that the common law rule was not to apply to claims under the Act. The second ground for the decision is that the statutory prohibition on the recovery of success fees is based on important policy considerations identified by Sir Rupert Jackson's report on litigation costs, published in 2010. He concluded that CFAs and success fees were the major contributor to disproportionate costs in civil litigation. In the light of the purpose of the statutory prohibition, the Court considers that the words costs orders in section 58A6 should be construed as referring to any order that deals with the costs or any part of the costs of the proceedings. To the extent that the judge's order for financial provision in the present case included a sum for the daughter's success fee, it was therefore a costs order for these purposes. This result serves to give effect both to the common law rule as to the treatment of costs and to the purpose and policy underpinning section 58A6. In its judgment, the Court of Appeal drew an analogy with awards in financial remedy proceedings under the Matrimonial Causes Act 1973, where a party can recover its legal costs as part of the substantive award. The Court does not accept that a valid parallel can be drawn between proceedings under the 1975 Act and financial remedy proceedings. The latter are governed by a substantially different costs regime, which in the main makes no provision for the payment of costs, and in any event, success fees are prohibited in family proceedings. For these reasons, the Court holds that in determining the appropriate relief to be awarded in a claim under the Inheritance Act 1975, a judge cannot include directly or indirectly any allowance for a success fee. The appeal is therefore allowed.